Cooley. Case number is 24TR65. Are you Gordon Cooley? You'll need to unmute your screen, sir.
Yes, I am the man that is that person.
So you're Gordon Cooley?
Yep.
Very well. State appears by Jill Gillette, County Attorney. Mr. Cooley, there's been an amended complaint filed on, it looks like April 17th. You're charged with driving while suspended as a second offense for on or about March the 25th of 2024 in Elk County, Kansas. If indeed you have a prior conviction where this would be a second offense, that's a Class A misdemeanor. A Class A misdemeanor is punishable up to 1 year in the county jail and a fine not to exceed $2,500. Additionally, with a second offense for driving while suspended, there's a mandatory 5-day minimum sentence. However, a person can be placed on probation from that. But there is mandatory sentence that would have to be imposed. Do you understand what you're charged with?
No, I don't quite understand.
At this point, I have come to realize that I have yet to encounter a sovereign citizen who truly grasps the reasoning behind why laws apply to them. Despite their lack of understanding, they continue to act as if they are exempt from legal obligations. Time and again, they challenge rules they don't fully comprehend, ignoring the very structures that govern society. Their defiance seems rooted more in belief than in logic, and yet, the consequences of the law still catch up with them every time. It's fascinating and often frustrating to watch how certainty in their own interpretation clashes with reality. No matter how much they protest or resist, the law applies to them just as firmly as it does to everyone else.
I think this is a matter of a mistaken identity. My persons was never involved in anything. I'm carrying my property from point A to point B. There's no vested interest of the state to even stop me. I'm exercising my God-given constitutionally protected rights, and I stated that to the man acting as the police officer. I didn't present him with a license.
You are charged, sir. Hold on. You're charged with driving while suspended, a second offense. That would indicate to me that you've had a first offense.
No.
Have you been in court before on this type of charge?
Nope, not on driving while suspended. No, I have not.
All right. Well, that is what you're charged with. You don't have to agree with it. You can certainly, that is an issue at trial if you feel you have a defense. As with the others that I've explained, you have certain rights. You are charged with a misdemeanor, so you are entitled to be represented by a counsel. And if you wish to apply for court-appointed counsel, if you meet the financial guidelines, I would appoint one to represent you. You also have the right to represent yourself. You also have the right to have counsel of your own choosing at your own expense. So at this time, if you wish to have a trial, if you wish to speak with an attorney counsel, would he qualify under any programs you have since you charge this as a second offense?
No.
All right. So apparently diversion wouldn't be an option for you. So if you're wishing to have a trial or to speak with an attorney, your plea at this time should be not guilty. If you wish to plead guilty, then we'd proceed to sentencing. But based upon what you're telling me, those would be issues that could be addressed at trial. So at this time, how do you wish to plead?
It seems someone got a little carried away at the breakfast buffet this morning. Perhaps they went overboard with the colorful options, indulging far more than they probably should have. Their plate looked like a chaotic mix of every item available, piled high with no thought to moderation. Watching them navigate such an overwhelming assortment was both amusing and a little alarming. One could only wonder if they realized just how much they were taking on at once. Breakfast, after all, is meant to be enjoyed, but there are limits even at a lavish spread like that.
And I will enter a plea of not guilty on your behalf.
Okay, I exercise my right to trial by jury then. I'd like to face the man or the woman that claims I've done them harm or loss.
Mr. Cooley, if you wish to have a trial by jury.
I'm I'm not Mr. Cooley. I'm Gordy. I'm a man. I'm not a person.
All right. Mr. Cooley.
Can I ask you a question,
Cooley.
sir?
You need to be quiet for a moment, and I'm going to explain what the situation is. You have the right to be represented by counsel. You entered a plea, refusing to enter a plea, which is fine. A person can stand mute, and I will set this matter for trial. If you wish to be or have a jury trial, you have the right to do so. However, you need to do that in the proper form. With a misdemeanor offense, you have to file a written motion for that request. Otherwise, it's set before the court. So you would need to do that in a timely way. If you're going to represent yourself, you would have to follow the rules as though you're an attorney. So all of those things would, most people don't have the training to where if they're going to do a jury trial, they're better off being represented by counsel. But that's a choice that you're going to have to make.
Okay, can I ask you a question?
Yes, you may.
Can there be a valid cause of action without an injured party?
Sir, that's not a valid question for what we're doing here today.
I've tried settling this matter in the private twice. If you have any papers in front of you with my signature on them, it's because...
Take a deep breath, Gordy. Those people weren't your captors. They were police officers doing their job. They gave you a choice. You could either sign the paperwork agreeing to appear for your court date, which you did, or refuse to sign and face immediate jail time while waiting for a magistrate to set your bond. You made the practical decision, the one that kept you out of unnecessary trouble. Is it really worth being upset over a choice that was clearly in your best interest? Sometimes the smartest move isn't the one that feels dramatic, but the one that simply avoids more complications.
What a man thinks that he has the authority to take another man and throw them in a box when they have harmed no man or woman, no
Mr.
claim
Cooley,
has been brought
Mr. Cooley,
against them.
You need to be quiet now. We're going to give you a court date, and you can advise me how you're going to proceed at that court date. If you're going to apply for a jury trial, then you'll need to make that application by that time. Otherwise, you'll be set for a bench trial. That's before the court. Sarah, could you give us a date, please?
What sort of time frame would you like, Judge? 30 minutes?
Approximately 30 days, 30 minutes would be fine.
We can do May 15th at 2:30.
At
Judge,
2:30?
I'm out that afternoon. We could do 11:30 if there's nothing else scheduled there.
We put that for a trial for an hour, didn't we? So
We could, if you only need 30 minutes, we could do the 11 to 12.
well, we said something at 10:30, I believe, or was it the 10 o'clock that was set for trial?
It was the 10:30 to 11:30 that was set.
Okay, let's set this at 11:30 for a pretrial. So, Mr. Cooley, you will need to appear at the courthouse in Howard. And if you're going to file a motion for a jury trial, you need to have done so by that time. If you're going to hire an attorney, you need to do that. If you're going to apply for an attorney, I would suggest that you do that as soon as possible, so that you can have counsel at that time.
Am I going to be able to face the man or the woman that has a claim before me, or are you going to discharge the matter? If there's not a man or a woman here, then this matter needs to be discharged.
Sir, I've heard these arguments before, and those are not legal arguments. Somebody's made these things.
I'm not a member of the legal society.
Sir,
Can you bring the law to the court, please? Can we bring the law to the court?
Mr. Cooley, stop interrupting. At your hearing, if you have motions that you wish to have heard, you can file them in advance. I would strongly recommend you be represented by counsel. But your court appearance is May 15th at 11:30.
Go ahead and try, but history shows it hasn't worked before, and it's not going to work this time either. It was satisfying to watch Judge Lee completely shut down the sovereign citizen arguments with no hesitation. However, not every judge handles things the same way. Our next courtroom session features Judge Collier, who approaches these situations with a slightly different style. His method is less flashy but equally effective in keeping the nonsense in check. Let's see how this new approach unfolds when sovereign citizen tactics are tested once again.
Good morning, sir. How you doing this morning?
I'm well. How are you?
Fine.
Morris had previously, there was one case that I was already representing him on. I don't know that we ever got one on this most recent charge. Okay.
Let me see.
Mr. Morris, I know Mr. Hill was representing you in the 23174 case. You're here for an arraignment on the 24 CF49 case. Has your financial circumstances changed?
No, sir.
All right, I'm going to appoint the law officer here, remarks.
You were handling things perfectly when you were simply sitting quietly, keeping your thoughts to yourself. Everything was going smoothly, and it seemed like you had a good grasp of the situation. But then, for some reason, you decided to say something. That one moment of speaking up changed everything. It turned what was going well into a completely avoidable mistake. Sometimes staying silent is the smartest choice, and speaking at the wrong time can undo all the progress you've made.
Yes.
Now that Mr. Hill is representing you, you probably want to talk to Mr. Hill before you say anything. We're recording this proceeding, so anything you say may be used against you. But I'm listening to whatever you want me to consider.
I'm not real sure what Mr. Morris is trying to claim in that writing right there. Said he's not.
There really needs to be a stronger approach to dealing with these individuals. It would only take a few clear examples before the rest of them understand the consequences of refusing to acknowledge their citizenship. Without accountability, this behavior is likely to continue unchecked. Setting firm consequences early on would serve as a powerful lesson. It's about making sure everyone understands that actions have real, enforceable results. Sometimes, the only way to teach responsibility is through consistent and unavoidable consequences.
Jose Morris, a secure party creditor under the UCC-1 filed in Florida. American national being held in custody in Gulf County, which is not a 14th Amendment citizen of the United States. Not a record. So documentation, which is official records. So stated, I'm the agent of the said principal.
Who wrote that for you?
I did.
Why do you need to read it if you know what you're talking about?
This memory.
Okay. Tell me what the 14th Amendment says.
That you were considered a slave under the 14th Amendment.
That who's considered a slave? I'm not a slave.
No, the incarcerated person. This, if you commit a crime.
Okay. Doesn't say if you commit a crime.
Or yeah.
That's not what it reads.
I got the 14th Amendment really wasn't in the book.
What book?
The book that we have in the back.
What book do you have in the back?
It's a law book.
What law book is it?
Florida statute book. Yes.
So the 14th Amendment isn't in the Florida statutes? That's because it's an amendment to the U.S. Constitution.
Mm-hmm.
So you don't know what the 14th Amendment reads?
The 14th Amendment reads.
It looks like you've chosen the wrong judge for this strategy. It amazes me how some people are willing to face real jail time just to represent themselves. Even more astonishing is that they don't fully understand the material they believe supports their case. Their confidence is completely misplaced, yet they persist as if they have a chance. Watching it unfold is like witnessing a train wreck in slow motion. You can't look away. Despite the chaos, there's something oddly captivating about seeing their determination collide with reality.
Tell me what the UCC 1 reads.
I wish I had my documentation in front of me to present it all the way. I wish I had someone here that was supposed to be here so I can have it.
I asked you who wrote that for you. You said you did.
I wrote it. Yes.
So do you know what you're talking about?
Yes, sir.
All right, so tell me what the UCC 1 reads.
It's the Uniform Commercial Code filed with the Secretary of State or within the entities under the contract with the Secretary of the State to maintain Uniform Commercial Code records and database of judgment liens maintained by the Secretary of State.
Now tell me what UCC 1 reads.
It's a statement and it's a financial.
You don't know what the UCC 1 reads, do you?
Not on top.
You're not prepared. You're not prepared this morning with your sovereign citizen argument. You needed some additional time to prepare.
Yes, sir.
I'll give you some additional time.
How about 6 years or so, plenty of time for him to step back and actually learn the law he keeps talking about. Long enough, maybe, to earn a law degree instead of just quoting misunderstood phrases. What makes it even better is the judge's calm confidence throughout the exchange. It's as if the judge is thinking, "You're making this far too easy." Instead of entertaining the arguments, the judge sends him back to jail to reflect. The message is clear: study all you want, because those arguments will still be dismantled one by one when you return.
Being at the jail, I mean, I can find time between now and May 9th to go to the jail and take care of that.
All right, Mr. Morrison, you come back. Usually when sovereign citizens come in the courtroom, at least they can recite from memory a lot of the stuff they travel under. So next time you want to come with your sovereign citizen argument, be prepared, okay? I'll listen to you, but be prepared.
Yes.
But you're not doing justice to your fellow traveling nationals who consider themselves sovereign citizens if you're not prepared to even articulate what the argument is, all right?
Yes, sir.
All right, we'll see you May 9th at 1:30.
Today.
Be prepared next time, all right?
Yes, sir.
It should have a constitution in the back so you can read the 14th Amendment and be able to tell me what it reads. And
What it says right here. What is state?
we're going to May 9th at 1:30.
Machine into a contract.
That's not a contract. That's giving you notice that you're
Yes,
going to come back.
Just making sure.
You're fine. I'm not going to query you about what a contract is, but we'll talk.
Oh God, Judge, please, question him thoroughly, cover every angle. All right, everyone, that wraps up this video. A special thank you goes out to Old Squishy Garter for finding and sharing the Kansas video, which, unfortunately, will now be held in person, so we probably won't see any more updates from that case. On the bright side, the Florida cases are almost always posted online, so we can expect plenty more material from that same fool in the future. If you enjoyed the video, make sure to hit the like button, and if you didn't, hit dislike, but don't forget to leave a comment with your thoughts. Finally, subscribe and turn on notifications so you don't miss any of the upcoming content.